All right. I hope you're all doing well, Crim 4. Wow, here we go. We're going to be launching this class online as of right now. Crazy, crazy. But a lot of this stuff in this particular chapter, we got about halfway through it. So I'm going to go really quick through the first half because I'm fairly certain we already talked about a lot of this in class, but I know we didn't get to the second half. And I think I remember telling you this is my least favorite chapter, so bear with me. Let's get through this. We were talking about evidence. I know we talked about this specifically. The study of evidence is a study of regulation and the process of providing facts. Okay, federal rules of evidence. We talked about the fact that typically, in most instances, the courts are going to rule in favor of allowing evidence in. Blah, blah, blah. States have the right to make different laws. Trial judge has discretion in deciding whether or not evidence can come in. And when new situations arise, sometimes the judges have complete discretion to do what they feel is right. Blah, blah, blah. Same thing that we already talked about. Favor in rule of admissibility. Whew. Oh, I'm going there. Ooh, sorry, I went the wrong way. There we go. Admissibility. Okay. There goes my phone. Okay, so evidence can be a couple of different things. It can be a tangible item, or it can be a statement. Okay. A declarant is a person who makes a statement that is deemed evidence. Yes, we did go over this. I remember because I think I flipped you all off and said, could that be construed as meaning something? And I think we all agreed that if I flip you off, it means, well, you know what it means. Hearsay. We talked about hearsay also, and I basically said that hearsay is kind of rumor, not substantiated. Some people would say gossip. So hearsay is when a statement goes through more than one person. So we talked about this also. I think, let's see, Marshawn is in this class, and I believe Beatrice is in this class too, and Malaysia. Okay, so I'm remembering you guys. So let's say that Malaysia tells Marshawn, I heard Fernandez stole a car. And then Marshawn tries to go into court and say, well, Malaysia told me Fernandez stole a car. That's hearsay. If Malaysia saw me steal a car and she went to testify that she saw me, she's the one that actually witnessed me stealing a car, that is not hearsay. But if she tells somebody else and that other person tries to come and testify, then it is considered hearsay. We talked about examples. I think we talked about the fact that there are more than 30 exclusions or exceptions to the hearsay rule, which is super frustrating. Quite a few exceptions, yeah, like 30 something. Hearsay is a really frustrating legal concept that is honestly pretty far beyond my grasp. I know some basics about it, but the law is super complicated in this particular area. I know we talked about that. Blah, blah, blah. We talked about that. Yeah, we don't want the jury to be there when the court is deciding on whether or not to allow evidence, because you kind of can't unring the bell if the jury hears the evidence and the court says, oh, we're not going to allow that in. Well, the jury's already heard it, so that is obviously an issue. So you don't want the jury in the room when that is going on. Blah, blah, blah. Okay. Admission, rulings on evidence, oral statements. The oral arguments take place in court as to whether or not evidence should be allowed. Typically, the fairness rule requires that admission of competing evidence only when it ought to, in fairness, be considered. Judicial notice. Okay, here's another concept. This one is much more clear. Judicial notice. So when you are a prosecutor in court, or a defense attorney for that matter, but you have to prove basically everything. And this could be even considering something like the fact that the sun rises in the morning, okay? So we all know that. You and I know that. We know that at 6 or 7 in the morning, the sun comes up. The judge knows that too. So when an attorney says, we're asking the court to take judicial notice of the fact that the sun rises at about 7 a.m., the court can say, are we all in agreement that that actually is the case? And if both sides agree, then the judge can say, I take judicial notice of the fact that the sun rises at about 7 in the morning. I hope that makes sense, but what I'm trying to say is, so another example of a judicial notice type issue, let's say, for example, most of us live in the Fresno area. So if you live in the Fresno area, sometimes you become aware, just by being here your whole life, of what areas are maybe gang-infested areas. Let's say Sin City, over there by Fresno State, Bulldog Lane. It's a pretty well-known area for a lot of gang and narcotics activity. So that could be another issue that maybe a prosecutor would say, we're asking the court to take judicial notice of the fact that Sin City is a high-crime neighborhood. And the judge could say, I hereby take judicial notice, and the prosecution doesn't have to waste time proving that that is a high-crime area. Hopefully this is making sense. So basically it's just a time saver, so that every last fact does not have to be proven beyond a reasonable doubt. Okay? Now, typical, significant issues regarding someone's guilt or innocence, we're not going to ask judicial notice be taken, but kind of everyday mundane things that might happen. There we go. Okay. There we go. It's the same kind of thing. Blah, 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 blah. You guys can pause this as you see necessary and take more notes. Relevant evidence. We know what evidence is. It's something that kind of can either a tangible object or a statement in court. Obviously, no one cares about things like... So, relevant... I had to pause there for a second. Sorry. So, relevant evidence... Now, of course, I forgot where I was. But relevant evidence is something that's significant to the case. So, it doesn't matter... an issue that completely does not matter is not relevant evidence. Or no, I hope that makes sense. Relevant meaning important to the matter. Oh, good Lord, come on. There we go. Blah, blah, blah. Skipping. Character evidence is not admissible to prove conduct, exceptions, or other crimes. And I'm saying this slowly because I have a strange feeling a question about character evidence will be on your quiz. So character evidence, that's something like, let's say my son gets charged with a crime. And while he's on trial for whatever this crime is, I get called to the stand and I say, but he's a good boy. He does lots of good things. He's a good human being. He would never do this. That is not relevant evidence. In fact, it's not evidence at all. It's character evidence. It's me saying what a wonderful human being he is. It's not me saying he didn't commit the crime. So character evidence, the time in the court proceedings when character evidence is sometimes allowed, usually allowed, is during sentencing. So, but it is not used to, just because he's a good boy doesn't mean he didn't commit the crime. I don't know. I hope that makes sense too. Skipping, rape shield laws. This is something else that is in play in the court system. It used to be that when a rape victim made allegations of rape against a suspect, the suspect's attorney would drag up her sexual history, her history in general, would basically try and blame the victim for the rape. Like, well, she was wearing a mini skirt and a tank top that night. She must have wanted to be raped. Or, she previously worked as a prostitute, so she couldn't have been raped. Those are types of statements that can no longer be used in court. So rape victims have protections against that kind of evidence being used against them. Not against them, but in the case. There we go. Skipping. Witnesses. Every person is competent to be a witness except as otherwise provided in these rules. No mental or moral qualifications for testifying a witness are specified. Competency of hearsay declarants, federal rules, and young children. So basically what this slide is telling you is there's not a whole heck of a lot written anywhere that excludes people as witnesses. Young children are pretty tough to have as witnesses, but they still can be if the court deems the child competent. But there's no set rules that says if your IQ is below 70, you can't testify in court. That's just not the case. So the judges oftentimes get to have say in whether or not these witnesses are able to, yes, I'm skipping through really quick, so I'm gonna look at something, are able to testify. A witness may not testify to a matter unless evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter. Okay, so if you are not an expert witness, you are a lay witness, that's someone like you or me who just happened to witness a crime, you cannot testify unless there's evidence introduced that shows that you have personal knowledge of the matter. And in order to do so, you have to make an oath or affirmation, swear to tell the truth, the whole truth, and nothing but the truth. So a witness is required to declare openly in court that they will testify truthfully. So a lot of you are thinking, I always kind of think this to myself as well, like, why do we even waste our time swearing people in? People lie either way, right? Of course they do. But what it does, when a person is sworn in and they lie in court under oath, they can be charged with the crime of perjury. So that's why we still do that. And we still today swear witnesses in for that reason. Impeaching a witness basically is, obviously we talked a lot about impeachment this semester, but impeaching a witness is basically when another witness comes up and says, that first witness you listened to, they were lying, and I can prove it. Here's how. So that's what we mean when we're talking about impeaching a witness, basically attacking the witness's credibility. Blah, blah, blah. Something was interesting, at least in the Corey Muhammad case. He'd been making statements that he was mentally ill and that he didn't feel like he was competent to stand trial. He was impeached by correctional officers and his previous cellies who said, this dude said that if he was ever arrested for a serious crime, he was gonna fake like he was crazy. So that would be an example of impeaching a witness. Okay, so we have two different types of witnesses, and I already sort of touched on this, but we have lay witnesses. Those are non-expert witnesses. That's typically a person who witnessed the crime or knows some kind of information about the crime, as opposed to an expert witness. An expert witness typically was not present when the crime occurred. They may have some other field of expertise where they come in and testify as an expert. Examples of that would be like a ballistics examiner, someone who does gunshot residue tests, things like that. They will come in and testify in court. They are expert witnesses. They did not necessarily witness any of the crime, but they are experts as to certain parts of that particular case, and they're allowed to testify. Okay, so a lay witness, just like you and me, just your average everyday person who maybe has witnessed a crime versus experts. They're typically experts in the field. Okay, documents. Typically, if documents are going to be submitted in court, they need to be originals. A lot of this has changed so much. I mean, this law is still here, but using original documents nowadays, I mean, we're typically looking at mostly electronic stuff. So, public records, documents, summaries. I think we talked about the chain of custody. We talked about the chain of custody the other day, but let me kind of briefly go over it again. Chain of custody is a document that usually goes along with a piece of evidence that shows every person and every place, every person who has touched that evidence and every place that evidence has been. So it's called a chain of custody because it's a document that shows exactly who has had that evidence and where it has been. And that's important because if you don't know where the evidence was for any period of time, it could be tampered with, and typically that kind of evidence would get tossed out of court and deemed not good evidence. Summaries. Here we go. Hearsay. Blah, blah, blah. Federal rules. Witness. Expert. Versus lay. We made it. Cool. Chapter. I already forgot what chapter this is. I think it's... I don't know what chapter this is. But anyways, we finished it. Yay.